E ku iluna. Please rise. Ia ka'aha ho'okolo ki iki hano ua a koa ho maila. This Honorable Supreme Court is now reconvened. Inoho ilalo. Please be seated.
All right, please call the case. All right, good afternoon, aloha, everyone. Our proceeding today is being broadcast live on our YouTube channel as well as on Olelo. Counselor, are you both ready to proceed?
Yes.
All right. 30 minutes for each side. Mr. Strand, you'll have 15 minutes for your opening portion of your argument. We'll give you a light at 15 minutes and you can say 15 for rebuttal. And Mr. Vincent, 30 minutes with a warning at 5 minutes to go. Please proceed.
Good afternoon, Chief Justice Rechtenwald, Associate Justices McKenna, Edens, Ginoza, and Devins. May it please the court. Andrew Strand and Miles Briner from the Law Office of Miles S. Briner and Associates on behalf of Petitioner, Defendant Appellant Oscar Cardona. When the DPA in a jury trial stigmatizes the defendant as the Waikiki wrecking crew, cruising the streets of Waikiki with impunity and destroying dream vacations by putting drunk tourists through the, quote, buzzsaw, he inflames the passions and prejudices of the jury. By using descriptive adjectives of such an incendiary nature, and without tethering the same to any legitimate evidence in the record, the DPA commits prosecutorial misconduct, and that's why we are here today seeking a new trial for Mr. Cardona. I'll just highlight 6 points that I will focus on as far as some of the more egregious instances we flagged. First, in closing, come on, be truthful. That is tantamount to accusing Cardona of lying on the stand, which this court frowns upon as we've just revisited in Browder recently. I'd like to focus on the pen instead of the knife, portraying Cardona as too dangerous to hold a knife in front of the jury, a knife that was in a sealed plastic container after he had safely handled scissors to open up another exhibit. I'd also like to focus on the we arguments by the state in terms of indoctrinating the jury, inuring it to its case, and rendering them, rather than a fair and impartial body, partisans to the state case. The comments that were sought from Cardona seeking to hear his take on the veracity of Horn's testimony was also inappropriate. If we have time, we can get to the leading questions. And finally, the DPA repeatedly ignored the trial court's admonishments and instructions to the point where the Intermediate Court of Appeals felt compelled in a footnote to call out his contumacious conduct and refer him to the professional guidelines of civility and courtesy. When you have a murder case where the cause of death is a stab wound to the heart, a 1 centimeter nick that the medical examiner needed to lift something up to see that wasn't necessarily fatal, and when you bring the defendant up to the stand to testify, and when you lead him along this narrative arc to build your case against him and his credibility, that is inappropriate as far as giving him a pen instead of a knife, especially in a jury trial where the jury is sitting but a few feet away from the witness box and where the state has entrusted to its first witness, evidence specialist Matsuda, a scissors to open up the envelope containing state's Exhibit 1, Cardona's self-D headset, his glasses at the time of the incident. And when the state also entrusts HPD evidence specialist DeMello to hold the actual knife in question, again, in the sealed plastic container. But when you ask the defendant to demonstrate with the pen, because I don't want to give you the knife. I don't want to give you the knife. You as the DPA, you're expressing a personal opinion, a belief about how dangerous this individual is, and in a stabbing case that resulted in
Mr.
death.
Strand, isn't there another interpretation, which is simply, it's not good practice for people to be waving knives around in courtrooms wholly apart from any proclivity that this defendant may have? I mean, there's other ways of reading the statement. It's not, the interpretation you have is not the only one.
When you say, I don't want to give you the knife, that brings it into the realm of the prosecutor's own personal belief and his own expressions, which has no place in a jury trial where the jury must independently evaluate the weight of the evidence. But to your point, CJ, yes, maybe not the best practice to have knives waved around, but when it's in that sealed plastic container, we see the same thing when firearms cases where HPD renders them inoperable, safe to use in a courtroom.
Mr. Strand?
Oh, sorry, go ahead.
Oh, so sorry. Okay, so did anybody, no other witness actually took the knife out of the bag though to utilize it?
No, Your Honor, just evidence specialist DeMello for foundational purposes to enter it into evidence and to
Held it.
publish it by holding it up. So we did have a witness hold it up in court.
Right, I guess my question really is though, here, the question surrounding that statement in question, I don't want to give you the knife. It was, the prosecutor wanted to utilize something, an instrument to show the actions that were utilized during the time of the incident, right? So I guess I just wondered to what extent, to CJ's point, for purposes of what the questioning was, it made sense not to, to hold up a bag with a knife in it and instead just use a pen, which is another way to perhaps read that statement.
And when we look at the context, Your Honor, and I'm referring to the August 31st transcript at docket 24, page 193.
Yes.
It's in the context of, quote, so when you stabbed him. And again, as we learned from the direct testimony of Cardona and also his redirect, this was a factual dispute as far as whether he did in fact stab him, notwithstanding, of course, his utterances to Sutherland. But in that context, when the DPA refuses to hand the defendant State's Exhibit 1 saying, I don't want to give you the knife.
I'm trying to figure out in your co-counsel's long careers of being in courtrooms, when it's ever been a situation where a defendant is actually holding up the murder weapon, whether it's in a bag or not. Do you, in your experience, and I know it's a little bit more limited than perhaps me and Mr. Breiners and others, is anybody really ever holding up a knife anyway in a court, Mr. Strand?
And I think we're getting away a little bit from the actual point we're trying to make. It's that I language, that I verbiage, and that insertion of the prosecutor's own personal belief that
What
he
about
doesn't
this?
want to give
Is another interpretation, and perhaps knowing Don Picaro might be a little bit more inside ball on this, but he's just kind of adding a little levity to the proceedings by making that comment, and versus suggesting to the jury that this man is too dangerous to hold a knife that's in a plastic bag?
No, that's a very good question. And I just think in this context, in this case, in that line of questioning, there's no levity to be had, especially when this prosecutor is approaching the trial under the banner of all is fair in love and war without regard to the law and the curative instructions.
Can I ask you about your wrecking crew comment? Wasn't that just related to the woman there and really wasn't related to your client?
The Intermediate Court of Appeals thought so. They interpreted it as, oh, I wouldn't want to run into them, right? In a case where we have the voluntary act instruction and a question of fact as far as the mode of actual stabbing and whether Cardona just reacted or not. But they're not part of the crew. These two were two strangers that Horn had met that night. They were from different parts of the country. They weren't together as part of the crew. The crew, the only reasonable inference that could be drawn was the crew is Horn and Cardona, specifically Cardona himself, which is why we have the state going on at length in its presentation.
Why not the women? Why not the women who were there? And there was sort of comments. It was in the context of commenting about sort of how they were conducting themselves. I thought that's how the comment came out.
But when you look at the total context of the trial and how Cardona was portrayed as, again, just cruising around the streets of Waikiki with impunity, how he was known to the crime reduction unit, how he was familiar with where the police substation was. And I know that was in the context of, hey, why didn't you call 911? And he's saying, oh, this all happened in an instant. But you don't get to label or stigmatize defendants during this case, especially when it goes part and parcel with attacking their credibility, and where credibility is the crux of self-defense, and where the only defense posited by Cardona at trial was the defense of self and of others.
Can
Why
I
don't
go
you-
back to your, I'm sorry, go ahead, Chief
Yeah,
Justice.
why don't you comment, if you could, on the comments in closing by the deputy prosecuting attorney? Come on, be truthful, and then also people lie. What's your take on those? As I think the ICA thought they were general comments. You know, how do we know that people lie refers to the defendant, and so what's your response to that?
Well, in that context, the DPA was saying the evidence doesn't lie, people lie. But jurors are supposed to reach their own conclusions on the basis of common sense, common understanding, and fair beliefs, grounded on evidence consisting of direct statements by witnesses or proof of circumstances from which inferences can fairly be drawn.
So you're now conceding that the statement "people lie, the evidence doesn't lie" wasn't in reference to your client?
In reference to my client, it was absolutely, Your Honor, as far as the
Because right before that, and I was actually going to ask you what, on page 78 of the closing argument, the DPA said, defense wanted to stip. Oh, we stipulate. But see, when you do a stipulation, you have to accept those facts as proven just as they are, just how it's read, without any explanation. You've got to accept it. People lie. The evidence doesn't lie. You have these photographs. What stipulation was he referring to? That the police could identify him? Was that the stipulation?
You know, that's what I gathered from my reading, Your Honor. But in terms of that comment, that brings us back to the Hirata realm as far as defendant's party status. When you're singling out these stipulations, which the jury, I construe the prosecutor as saying you must reluctantly accept these as true, but when you look at Cardona's testimony itself, and as the defendant in this case, come on, be truthful, has no other reasonable interpretation other than Cardona lied. And as we know from Browder, you can't say that in closing, you can't say that in court, you cannot accuse a defendant of lying, especially, again, when it goes to credibility, which is the heart of their self-defense.
Actually, in this court in Austin did allow it. It didn't forbid it absolutely, as long as there's a reasonable inference. It's like the defense can make the argument on credibility, but not the prosecutors. But if there's a reasonable inference based on admitted evidence, can't they make that argument and say someone was less than truthful, maybe less than candid? Why shouldn't it be an even playing field on that?
We're not
in that regard?
suggesting an uneven playing field.
It
we are
sounds
just-
like it.
We are suggesting that in this case, had the defense counsel said, come on, be truthful of the state's witnesses, that also would have been inappropriate. But you're right, the prosecutor is allowed to comment on the veracity of its own witnesses, of any witnesses in the case, attack their credibility, but we have jury instructions.
Okay, but let me ask you, was there any evidence to make that kind of statement? Because isn't that really where the issue goes? They can make statements about someone's credibility if there's a basis in the evidence. Was there any evidence to make such statements?
None that the prosecutor tethered to while making that argument. It was just a boom, come on, be truthful. If he had explained the inconsistencies perhaps in Cardona's testimony as compared with other witnesses, perhaps we get a little farther away from his conduct. But isolated in that one line, come on, be truthful, without more.
And when he said people lie, wasn't that more of a general statement? People lie. And then he was saying, but look at the evidence. The evidence doesn't lie. Wasn't he just focusing the jury on what to look at? Take a hard look at the evidence that we have admitted and see where the truth lies there.
And we see that context of being looked directly at Cardona's testimony. Look at
Well,
that.
he wasn't the only one that
evidence.
testified.
For the defense, yes. So
But there are other witnesses.
Yes, Your Honor. But in this case, the DPA was singling out Cardona, and again, based on his party status, to attack his credibility, to tell the jury that he was not being truthful. And yes, it's appropriate to refer them back to the evidence, but there was no evidence tethered to that comment. It was just a general, please refer to the evidence.
Wasn't he, when he said, come on, be truthful, isn't he challenging the plausibility of the defendant's version that the complaining witness ran into his knife?
But
Is
was
that-
it the defendant's version? If we look to the cross-examination of Cardona, we have the DPA leading him there all the way. We have Cardona.
Leading's okay on cross, and he did eventually say, maybe he ran into it, I thought.
He did. But again, when you're overwhelmed by the testimony of the prosecutor by telling you, hey, look, you're the one that's doing the stabbing, as opposed to the fact-finding mission of what really happened, Cardona doesn't know what happened. His self-D headset was knocked off. He can't see. He knows he's being attacked. He knows he's defending himself. But as far as whether the decedent is charging at him, running at him, walking at him, that's a factual dispute, and the jury should have been able to evaluate it for themselves, free from the outside influence of the prosecutor, who in this way made them partisans to his case.
I have a question regarding page 90, where the DPA says, but remember, there's no credible evidence that he can't see. There's no credible independent evidence that he had an eye problem. So is that the DPA basically saying that he's basically saying that your client is not credible when he said that he couldn't see very well without his glasses?
And that's how the DPA closed his rebuttal, where as the final person to have a say before the jury takes the case to deliberate, again, he's attacking that self-D headset, that subjective belief. I don't know that that's tethered specifically to the come on, be truthful comment. And as far as the credible evidence, I would suggest that
What was the
misstated-
basis for the DPA calling your client an enforcer, or like an enforcer?
He tethered that to Horn calling him for help when Horn was faced with two assailants.
Wasn't there also, didn't he also make the argument about the demeanor of the defendant as he rode around on Waikiki and was picked up on these vehicles?
Absolutely. Sometimes with his lights on, sometimes with his lights off, sometimes going the right way, sometimes going the wrong way. They portrayed this defendant as someone who ruled the streets of Waikiki at night, responding.
This is why I'm asking you what the stipulation was supposed to be referring to.
That was for the identification. We have Sutherland identifying defendant. We have Gunderson from the hotel identifying him. And yet the state still felt compelled to introduce the testimony of Detective Resents and Officer Cohen as far as the police identifications of defendant, which, as we learned from State v. Gabriel, is inappropriate when we don't have a curative instruction to limit any adverse inferences the jury could draw from the same. And to be sure, of course, it was just that one COVID citation. But again, with Officer Cohen saying he's part of the crime reduction unit, that he was told to go look for the guy, look at this video, right? The Plekhanov video. Look at this video. The police gave it to the other police. They said, go looking for this guy. And the crime reduction unit officers brought up to the stand to identify him, where ID is not an issue in this case.
Oh, sorry.
He testified that he was crime reduction unit?
Officer Cohen, crime reduction unit.
Can I come back to the part about the last remark made by the prosecutor in his rebuttal closing? But remember, there's no credible evidence he can't see. So can he not argue that the defendant's testimony was not credible? Is that not permissible?
The defendant's testimony wasn't the only testimony, and I see my time is short, so I would like to save some
You can
for
answer the
rebuttal.
question.
But as far as the defendant's testimony was concerned, we have him discussing his journey with eyesight problems. But we also have Horn discussing his eyesight issues as well, and that was credible independent evidence from one of the state's witnesses.
But what about, can he not characterize that as not credible? I mean, what's he supposed to do what is a prosecuting attorney supposed to do if he wants to suggest to the jury that they should reject that testimony because it's not believable?
Well, in this case, given the nature of the eyesight testimony and because ordinary jurors may hold myths or misconceptions about eyesight issues, glasses, optometry versus ophthalmology, this personal comment by the DPA, again, it was a personal opinion attacking his eyesight. It was a direct attack on his credibility and his claim of self-defense. I hope I satisfactorily answered your question.
Yeah, I guess I'm just trying to understand if the prosecutor wants to challenge the credibility of a defense witness. You know, we said you can't call him a liar. Okay, you know, that we've held that. But can you not just say, hey, there's no credible evidence? Is that what's wrong about that assertion?
That
To
blanket
simply
statement,
say there's no credible evidence.
I would suggest it's a blanket statement that allows the jury to speculate as to what evidence the particular argument is being tethered to. Then they have to go back and mine their recollection while also juggling these jury instructions to determine what really happened. And this
Is the prosecutor inferentially testifying, is talking about these witnesses' credibility?
That is our-
Isn't by saying that there is no credible evidence when two people have testified as to an eye problem, the prosecutor then is saying that these people, is giving an opinion that these people are not credible?
And again, that's the point. You're not allowed to give that opinion as the prosecutor in
We
rebuttal.
did clearly say in Austin that when it's the prosecutor who inferentially expresses an opinion about witness credibility, it's particularly problematic. And we were very clear that the word lie is not supposed to be used. And it was used here. People lie.
Well, people lie and come on, be truthful. Meaning Cardona lied. And that's inappropriate.
A prosecutor's statement that a witness lied may imply special or secret knowledge of the truth or of witness credibility beyond what has been presented at trial. And that's from the ABA prosecution function standard.
Absolutely. And the
Can I ask
DP,
one last question, Chief Justice?
Oh, of course.
Yeah. You seem to attach some special significance to crime reduction unit as opposed to police. I don't know if I'm reading anything into that. I just wanted to ask you.
well, I'm not sure that an ordinary juror would know the difference. And when you're telling that, when you're telling a juror, a common citizen, that this particular defendant's under the supervision or he's known to a specific unit within HPD that specializes in reducing crime, I mean, that's that uncharged bad act stuff. This is that 404B. This is painting Cardona as a bad person and letting the jury run wild with their adverse inferences. So absolutely, especially where the state has made it clear that only the HPD witnesses in its case are to be trusted. Thank you. I will reserve my time for rebuttal.
Very well. Thank you, Mr. Strand. We'll hear from Mr. Vincent.
Good morning. This is a sad case. I mean, we have a 19-year-old boy who died, and we have a 23-year-old boy who's probably going to spend a considerable amount of time in prison if this judgment is affirmed. But the defendant was the only one with a knife on this night, and he had three other people on his side, and he was fighting two people who were just dead drunk. If you see the video, and there was plenty of evidence to support a guilty of murder in this case. Let's address.
Did the videos show the actual, I thought the videos didn't show the actual
They did
point
not.
of stabbing or
No,
contact.
Yes. So if you look at the Plekhanov video, which was the first video taken by the Russian tourist, right? It just shows the start of the fight. Right, he comes down from the wall, chest bumping, horn, the friend, and then you see some action going forward, and I think the big friend of this decedent tries to get in the way, and you see defendant coming forward, and you could see the knife in the video. Okay, we don't know whether there was contact made at that point. There was blood found at that point, but we don't know what happened. And then Plekhanov went off to call the police, right? So he couldn't take pictures anymore. Then a person named Montoya starts taking it from the, 15th floor, high floor of one of the buildings. And you see Osvaldo, the big friend, fighting with Horn over here. And you see there's a tree over there. You see Plekhanov over on the other side. you see a tree, and that's obscuring where the stabbing took place. So you don't see the actual stabbing. So you don't have that on video. And the only person who saw that is defendant. So.
Wasn't the whole case gonna turn on the defendant's credibility?
That's correct. Mhm.
And with that, what evidence was there to draw a reasonable inference that he was not being truthful?
I think that his assertion that the defendant, that the decedent ran into his knife was implausible. And I think that's the basis of our argument, that it was not plausible. In addition to the fact that, he had a knife, and he really didn't need to help these girls. Okay, and that guess brings us to this Waikiki wrecking crew comment. Okay, it clearly was in reference to the girls. Let me just read it right. The comment right here. It says, "These girls that Horn said they needed to be protected. I wouldn't want to run into them. They looked like the Waikiki wrecking crew. They beat up on those guys because they were drunk. They're too drunk to defend themselves, falling, stumbling." So that was his argument. And if you see the video, you'll see the girl in the stripy dress. She comes over and she whacks the decedent's friend several times over the head, 3 times over the head with a skateboard, then kicks him in the head. And then another girl, the other girl in the white top, she comes over and kicks him in the head as well. Okay. Then you see the girl in the stripy dress. She goes under the tree where we know that defendant was engaging with the decedent, right? And she's got her skateboard over her head, okay? And I believe that the medical examiner said that there was a contusion on the decedent's head. So,
Mr.
so
Vincent, in terms of the question that you were asked, though, what evidence was there that the defendant was not credible? I think what I heard you say was you pointed to the very, I think, crux of the case, which is his testimony that he did not affirmatively stab. Right? I mean, how can that be the evidence that shows his credibility or allows a prosecutor to suggest he is lying, when that is the crux of the question, really, before the jury? I guess, is there anything else that?
Well, I guess the other thing is that instead of going to the police and saying, "He ran into my knife, it was an accident."
But was that argued?
He goes home and we don't.
Was that argued by the prosecutor?
I believe so, that they had to go and find him, right?
Right.
He didn't come and surrender himself.
Don't they have to tie it to the statements that they are making? I mean, to the arguments that they're making in closing? Tie the evidence that they're utilizing to make the arguments.
With respect to
the closing arguments that were made.
Right.
Yeah.
So I think there was evidence that he did not turn himself over to the police. That I'm not sure if that answers the question.
Well, what about tell the truth? What's your response to that comment? Come on, be truthful. Pardon me.
I guess it's an exhortation to just be candid with everybody.
You don't think that was a reference to the reasonably interpreted as a suggestion by the prosecutor the defendant was lying?
I don't think it was. I don't think it was interpreted that way, I guess. I mean, I think everyone knows that,
Can I ask you about the other video? I mean, the deputy prosecuting attorney is talking about Cardona's, poor electric bike safety habits, and then runs from there and says he's the enforcer. And there was no evidence, no reasonable inferences that I can tell to make the statement that he was the enforcer or even the enforcer of Waikiki. So I'm just wondering, in your view, what does the effect of calling a defendant the enforcer have on a jury in a self-defense case?
Well, I think that was he says he looks like the enforcer. And so they're asking the jury to look at the video that was taken, I think the first one of Plekana's video, right? And he's making it in the context of saying that he didn't need to be the enforcer. These girls could take care of themselves, okay? And they did. They should. He didn't need to come and interpose himself in his friend's
What do you
argument.
make of the defense's argument that the defense had offered to stipulate that the police could identify the defendant, but you went ahead and called an officer who testified that he was with the crime
Yeah,
reduction unit? And if you allow me to finish, and then the DPA in closing says, you know, talking about the defendant, that ain't the guy you see today. You look at those videos, it tells you how a person is outside of court. Whoa, that's irrelevant. Well, that's relevant for you to look at because that's how he was on these streets. He looked like he owned these streets. He looked like an enforcer, right?
yeah, that's something that's.
And it isn't it kind of like suggesting that the reason the police knew him was not just because of the mask thing,
Well,
that, you know, he's known to the crime reduction unit of Waikiki because of the way he's acting like a big man and he's like the enforcer.
No, I think it was clear from the testimony of the officer that, I mean, the only evidence they had other than prior
Did the
contact.
officer say that that was the only contact I ever had
Well,
with him? I don't remember that.
I don't remember that either. And but I do think that if I mean, I think that the defense counsel could have asked that, and in fact I don't know whether or not there was any prior contacts other than this mask violations. These mask violations are pretty innocuous, and I think that, you know,
I thought
it shows that
I thought he had no previous arrests.
I don't think so. Yeah. So so unless there was some other contacts, or I would know.
Doesn't it suggest that there was other contacts other than
I don't
the
think so.
innocuous mask?
I think it just, I think what the DPA was arguing is that Cardona knows his way around Waikiki, and he could have gone and got help from the police. It was his home turf, so to speak, Waikiki. I think the testimony was that he grew up there, if I'm wrong about that. But I think that, you know, he was familiar. In fact, he was the one that was most familiar with Waikiki of anybody down there that day. The other one, the decedent and his friend were tourists. The girl, I don't know. We don't know about them. We never able to locate them. But
You know, there was the people lie comment, and that was followed by the commentary about the DNA evidence, but, you know, with respect to the blood on the knife. But Cardona was never really disputing that that was the knife involved. And it doesn't seem to me that the pejorative word lie was really tethered to anything there. Can you help me help explain how that comment, the people lie, right before the sort of DNA that didn't really matter as far as lying or not, didn't impact the jury's decision-making?
I don't think it impacted the jury's decision-making. I think it was a general statement that everybody can identify that people do lie. Maybe it wasn't the wisest choice of terms, but this case was really based on the hard evidence rather than the testimony, because the only person who witnessed the stabbing was the defendant. And all our evidence was video evidence, physical evidence, and so forth. So we wanted to point.
Wasn't the
jury.
DNA evidence that followed an attempt to say that it couldn't have happened the way he did because of the way where the blood drops were?
Yeah, it's not clear to me what the DNA evidence means. It was the two blood, I guess, the decedent's and defendant's blood were found near the garbage can there, right? Where the initial contact took place Plekhanov took the video of, and I'm almost wondering if that's when it happened, but anyway, his body was found up near the beach, in the sand, towards the beach, and what happened there, we don't know. I mean, the jury made their, they weighed the evidence, they made their determinants of credibility, and they came up with their verdict. So.
Well, you said that this case is really based on hard evidence, but the testimony of the defendant was crucial to all of it. Wouldn't you say? I mean,
It was
his
crucial
credibility,
if you believed it. Mm-hmm.
right?
Yeah.
So his credibility was at the heart of this case.
It was, but I don't think any of the comments were directly related to his credibility or an expression by the state that he was not credible just because he was a defendant or.
Do you think that in some trials, that leading questions that just, are all over the place, continual, that where the court has to step in on many different times, that leading questions alone, perhaps in some situations, can result in misconduct and the defendant's right to a fair trial being compromised?
I wouldn't say that it could never happen, but I mean, the leading questions in this case were called for relatively innocuous answers, and anything that was said in the question that was asked, where they asked for a yes or no answer was I think established in other places in the testimony and in the evidence. So. I don't see a great deal of.
I mean, because it does seem at times that the prosecuting attorney was sort of flouting the court's directives, and I'm just wondering if there's any situation where, that alone can really, the can impact the integrity of the proceedings.
I'm not saying it couldn't, but I'm just saying it didn't happen in this case.
Okay.
Yes.
Gotcha.
What about the time that the prosecutor was leading with respect to Mr. Horn and whether Mr. Horn had refused to meet with him?
Yeah, well, he was trying to lay a foundation for him as a hostile witness, so he could ask further leading questions, right? Because Horn was obviously, I mean, even though we presented him on our state's case in chief, he was hostile to us. He did not want to testify against his friend, right? As did the other older woman who was friends.
That was an interesting line of inquiry by the deputy prosecuting attorney, because didn't he make himself a witness by asking that question? I mean, shouldn't there be like a victim witness counselor or some sort of investigator that he should talk to? Mm-hmm. Didn't the prosecutor make himself a witness when he asked that question?
Well, I suppose so, but I don't know for sure that he did not have an investigator call him.
Well,
anyway.
That was my other concern, because it seemed like he was representing to the court that Horn had refused to meet despite having a meeting set up.
Yeah.
But then he started talking about, well, we paid for him to come back, and we had the victim witness counselor. It sounded like he was representing to the court hearsay that the victim witness counselor had told him, and he was representing to the court that he had those conversations until he mentioned that there was a victim witness counselor involved. So which was it? Was he the witness, or was he presenting hearsay as direct evidence, misrepresenting hearsay as direct evidence?
Some of this conversation took place outside of the
right. Was it the
jury,
victim witness counselor that had actually spoken to Mr. Horn, or was it him? Because if it was him, he made himself a witness. If it wasn't him, and if it was the victim witness counselor, he was representing to the court that he knew that these appointments had been made, and that Horn had refused to meet with him when he had never spoken to him.
Well, he made those representations outside the presence of the jury, I believe, right? It was in the sidebar, I think. So,
I'm talking about how he represented it to the court.
But I mean, I agree. It probably would have been better to have somebody just come in and testify, but he didn't want to talk with the deputy, and that probably would have laid the foundation for him as a hostile witness. So, I mean, that is what it is.
Can I ask you, Mr. Strand made a point that I certainly can appreciate about a crime reduction officer
Mhm.
being called to testify, but
Mhm.
he was actually part of the arrest, wasn't he? He was an arresting officer.
Yeah, yes, I believe so, right?
Right, he
Yeah,
went back to wherever it
Right,
was
right.
at 6 PM, whatever, and then
Right, right.
he actually arrested the defendant in this case.
I'll trust you on that. I probably did,
I
yes.
think that's what I read from the
Yeah, yeah,
record.
yeah.
And then when he was on cross-examination, that's when it came out about the prior interaction that Officer Cohen had with the defendant. Isn't
Right.
that how that all came out about the COVID citation and whatever interaction they had? But it was on cross-examination when that
Yeah,
was brought up.
yeah, that's
Did I read
probably
it
what is.
correctly?
I'm not sure. I can't tell without probably going back and look at the record
Thank you.
again, but, yeah. I mean, you and I, if we heard crime reduction unit, we probably would, our antennas would go up, but I don't know what the jurors think. And I think that in this case,
Well, it
the
wouldn't-
testimony that they were
It wouldn't
issuing
be
mass.
unnatural for a crime reduction officer to come under these circumstances, right? If this officer had.
It wouldn't be unnatural in this circumstances?
Yeah,
you-
that wouldn't be unnatural.
Probably not, yeah.
Well, they're actually part of patrol.
Yeah, right. But I mean, they do go out and look for people. They do have people on their lists and they go out and look for them, right? But in this case, they obviously were doing much more innocuous things like giving them mask violations. I mean, this was COVID, right? So. Let's see. A use of the pen instead of a knife. First of all, I don't think the DPA intended that to be, an attempt to stigmatize the defendant. In fact, it possibly might stigmatize him to be waving around a gun or a knife on the stand, before the jurors. They might, fear him, possibly. Who knows? It's probably not good practice to be waving around a knife or a gun on the stage.
Again, I don't think I've ever seen that anyway.
Yeah,
I
probably
mean,
not. Yeah.
But
I've heard stories about people putting guns together and putting ammunition guns and shooting them off in the jury room, but
but you agree that, I mean, really, he shouldn't have made the comment, I don't want to
Probably
give you
not.
the knife.
Yeah. I mean, every DP has their own
He
style.
could have said, why don't we just use the
Okay.
pen
Yeah.
or this ruler or something like
Yeah.
that?
I mean, every DP has their own style, and we might like it or we may not like it. It's, people make their case in different ways. So.
Well, it's not a matter of liking or not liking, it's a matter of being prejudicial.
Right.
Or harmful to the
You're
defendant.
correct, yes. Well, if you don't have any more questions,
No?
Thank
Mr.
you.
Vincent.
Thank you.
Mr. Strand, your rebuttal.
Briefly, the we statements. We got the video. We got the DNA. In the context of these exhibits, this evidence for the jury to consider for the deliberation, again, the prosecutor is bringing them in to his ken. He is inuring them to his case. He is making them partisans in the prosecution's case, as opposed to fair and impartial jurors. Tether that to the I don't know comment when he's attacking the self-defense. He's offering his personal opinion about whether Cardona's use of self-defense was appropriate under the circumstances. I don't know. That's September 1st transcript, page 83, lines 20 to 21. Referring to facts not in evidence. They had so much evidence, they couldn't even test everything, so there's no hole. And as far as, I thank you, Justice McKenna, for bringing up the videos, because it was also in the context of commenting improperly on Cardona's right to remain silent. The whole, everybody's on their best behavior when they come to court. That is commenting on Cardona's behavior when he's not on the stand, juxtaposed against his behavior as the Waikiki wrecking crew, riding his bike around as the enforcer. You can't witness what you can't see. So again, based on the testimony that Cardona couldn't see anything, maybe just shapes. I don't know that we can say he witnessed the fatal stabbing. And as far as the hostility of Horn, I think Judge Morricone below specifically informed the DPA that he had not made that finding and that he would, when appropriate, if appropriate, and that finding was never made. And again, this was the state's witness. Finally, this is very similar to Browder, where we had a trial strategy. We had a narrative arc. It deliberately and purposefully commented improperly on defendant's credibility and solely based on his party status. We had a veteran DPA seeking a conviction at all costs because, quote, all is fair in love and war. And that's not okay because as prosecutors, you don't just take the one oath to be an attorney in this this jurisdiction. It is sacred, it is sacrosanct. You are a minister of justice. You not only swear an oath to be an attorney, but also to be a prosecutor and to not inflict the foul blows that the Supreme Court despised in Berger. Thank you for your time. If there are no further questions, I have nothing else.
All right. Thank you to both of our attorneys for your arguments today. The court will take this matter under advisement.
Ua ho'oku ia mai nei ke aha ho'okolo ki ike hanohano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.